All right, everyone, we're going to call the April 21st meeting of the Scituate Zoning Board of Appeals to order. Before we get started with our agenda, actually, we'll start with the announcement that this is a hybrid meeting. So as you can see, in addition to the folks that we have here in the hearing room, we are also available on Facebook Live, and also participation is available via Zoom. The login information is available on the ZBA's website. And obviously we have those folks here and present in the room with us virtually, where participants, you'll be able to raise your hand virtually, or if you put on your video and raise your hand, we will make the public comment section of each application available to our remote participants as well. Also, before we get to our agenda, we have an announcement. The Scituate Zoning Board of Appeals is committed to providing an environment of respect during meetings. We ask all members to interact in a polite manner, even when there is a disagreement. We value the participation of our community and want all participants, including marginalized and minoritized communities, to feel welcomed and respected. We ask our committee members and all who participate to commit to these standards and to support and respect our community. All right. We're going to begin with the first application brought by Thomas P. McCarthy of 49 Aberdeen Drive in Scituate, who is requesting a special permit or finding in accordance with MGL 48 Section 6 and Section 810.2 of the Scituate zoning bylaw, and or any other relief that the Board of Appeals may grant, to allow the raising and reconstruction of a pre-existing non-conforming single-family dwelling at 121 Jericho Road in Scituate, increasing the gross floor area by more than 20%. Is our applicant here or available by Zoom?
If the applicant is on Zoom, you will need to raise your hand. So if he or she is here, or you start your video, that's how we see you.
Let's see his name up there.
Seth, we don't see the McCarthy name up on Zoom. Do you have them?
You see all little boxes, right? There's no McCarthy available.
No. All right. We are going to move that. That will become our last application. I apologize for anyone that came hoping to speak on that application, but we're going to move them to the end of the line to keep this moving since they are not available. And we are going to move to our second application brought by Scott and Tara McGavin of 39 Arrowwood Drive, requesting a variance in accordance with MGL 48 Section 10 and Section 520.f of the byline and any other relief that the board may grant to allow for the construction of an in-ground pool and retaining wall at 39 Arrowwood Drive. And the board has received a request for a continuance of this application to our May hearing, to our June hearing, which will occur on the 16th of June. I would make a motion that the board grant the request for continuance to our June 16th hearing.
I second it.
All those in favor?
Aye.
Aye.
There we go. Again, the application for, Scott and Tara McGavin at 39 Arrowwood Drive has been continued to June 16th. We're going to move on to our third application brought by Edward Johnson of K&E Construction for Byron and Constance Leach of 50 Hazel Avenue, requesting a special permit or finding in accordance with MGL 48 Section 6 and Section 810.2 of the bylaw and any other relief that the Board of Appeals may grant to allow the raising and reconstruction of a pre-existing non-conforming single-family dwelling at 50 Hazel Avenue in Scituate. Great. Mr. Morse, welcome. If you could please tell us a little bit about the application tonight.
Thank you. For the record, Gregory Morse, registered engineer, Morse Engineering, representing the applicant, Edward Johnson of K&E Construction. What's before you is a Section 810.2 special permit of the bylaw, as well as a finding under 40A Section 6 for property located on Hazel Ave. This is a raise and reconstruct project for a single-family dwelling. Referring you to the plan, you'll see that the property line itself is the black line shown in bold. The property is 10,921 square feet in size, all of which is upland land area. It's located in the Residence 3 zoning district. There's an existing home constructed on the site, built around 1895 per assessor's records, 1,716 square feet of floor area. The lot itself is non-conforming with respect to frontage. 100 feet is required in the district, and this lot has 76.58 feet of frontage. The dwelling would be non-conforming with respect to lot width. Nowhere on the lot is there 100 feet of lot width present. And then the front yard setback. This lot, as you'll see, is a corner lot. With respect to Hazel Ave, which is where it derives its frontage and its legal access from, it complies with the front yard setback. However, it also has frontage on Harbor Heights Road. This section of Harbor Heights Road, the applicant has no legal access to it. Harbor Heights Road is a private road. It is not constructed at this location either. There is no pavement down, there is no access existing or proposed at this location. The proposal here is to take down the existing house, put a new one in its place. You'll see the location of the new house depicted in bold. It complies with the front yard setback to Hazel Ave, the side yard setback, and the rear yard setback, but the location, just like the existing house, does not comply with the front yard setback to Harbor Heights Road. It is an intensification. We are proposing it at an 8.6-foot setback, which is typical of a side yard setback at that location. The square footage of the new home is 2,933 square feet, which represents a 70.9% increase in size. We'd turn it over to you.
All right, so we're going Hazel Ave. Are we presently non-conforming on Hazel Ave?
No, it complies to Hazel Ave. Hazel Ave has an average front yard setback of 13.2. In this location, we're at 14.6.
Yep. Yep, but conforming. And then we are currently non-conforming along Harbor Heights Road.
Correct.
And we are becoming significantly, mathematically at least, more non-conforming. However, the point you raise is well taken. That's not just a private road, it is more of a paper street, if you will, in that it doesn't exist. And given the current setup of the lots, it's not likely to exist in the near future. Sorry?
Yeah.
I was not making a statement of opinion, I was more trying to get my eyes around this. Please, give us more.
So I was looking at the lot layouts on the town's website, the GIS, and there are at least two other buildable lots on that road. If it's not, I was gonna drive up there and I didn't. If it's not passable now, it will be.
From the other
guessing.
side.
I'm guessing they're gonna, I would bet they would go through, and that's an opinion, not, you know.
That's all we got, so
Yeah.
it's good that we have those opinions.
Maybe comments.
So I am, and for the audience, I'm on Google Maps right now, which we use so often in these types of scenarios. So Harbor Heights would be going
Harbor Heights,
here.
exactly, it's right in there,
So there
in between
isn't-
that tree
isn't
break.
a
But if you
ton
look at
of
the picture,
Space here.
if you look at this picture.
Yeah,
You can see.
there it is.
through.
Yeah,
Right, it's partial.
right. And so I'm not getting a picture as good as that on.
Right.
So, it does, it is a significant question. Obviously, you've done this once or twice before. You knew this was gonna come up in this application. 23 feet well inside of our 30 is very close and commonly in compliance under our bylaw, given our average setback rule, and we're going at 8.6. Today, I'm not sure we're that concerned about it, but he raises a good point that this could become potentially much more of a thoroughfare.
So when we looked at this originally,
Yes.
we had an initial discussion with the building inspector about treating that as a side yard setback, that the road was not constructed, it was not likely to be constructed, we had no legal frontage on it, we had no legal access to it. And we proceeded with that guise. I believe if you ask the building inspector, there was discussion as well with Neil Duggan regarding this portion of Harbor Heights Road, and it was, the opinion essentially was revised that we should hold a front yard setback to it, and in this case here, apply, for the special permit and the relief, where we had already laid it out, essentially complying with that previous opinion that it be a side yard setback. There are wetlands that would essentially prohibit development of Harbor Heights Road at this location to go through. There is a wetland on the opposite side of Harbor Heights Road that is present. The buildable lots, I believe, that are further down are accessed off of the other portion of Harbor Heights Road, which is paved and has utilities on it where you come up from Front Street, if you would. So access from Hazel here, it is currently blocked off. There are boulders in the way. There is no improvements to the street at that location. So that's why we proposed it with the setback that we did.
Yes. Any more questions? I think I want to hear from the public on this.
Yeah.
I want to certainly come back to us.
Right.
You have some more?
No, I'm just looking to see if the person that owns the property on Harbor Heights is the
Yeah.
kind that would build.
Yeah. Well, we're going to hear from everyone. So at this point, we'd like to hear public comments and questions on this application. Again, we're at 50 Hazel Avenue in Scituate. And so we would ask that anyone here in the hearing room or with us on Zoom raise their real or virtual hand so they can be called upon. And just once you are called upon, your name and address for the record, please. So again, anyone here for public comment on the application for 50 Hazel Avenue?
Anybody in the room?
Yes, ma'am.
Yes, ma'am.
Might be a silly question.
Sure, just your name and address,
Marie
please.
Sorensen, 56 Hazel Ave.
Thank you.
Excellent.
Where is the driveway going to be?
So I believe, and Greg, you can correct us here, that there would be no change in the driveway. Go ahead.
I'm going to correct you.
Please.
There's a brand-new driveway proposed which accesses off of our frontage. You'll see if you look at the house, there's a garage on the left side of the house, so that there would be a two-car wide driveway there.
Yeah.
Currently, there is no driveway at the site, so that's
Okay.
They used to drive in off of the Harbor Heights Road.
All
I
right.
think that's what they used as a driveway.
And, right, so I was mistaken in that I saw the curb cut line here, not realizing that that was a new curb
Yes.
cut. So the new driveway is proposed to be off of Hazel Avenue. Yes?
Neil Sorensen, 56 Hazel Avenue. What's the difference in setback from the existing house to the new house on Harbor Heights?
We're going from 23.8 feet to 8.6 feet is the proposal.
All right, thank you.
Thank you.
You're very welcome. We have anyone else for comment on 50 Hazel Avenue? Bob, what do you got for us?
So, in the Scituate Book of Streets and Ways, Harbor Heights in this area is indicated as a paper street. That's its category. And there is precedent for allowing that line to be thought of as a sideline. If you decide that a paper street is in fact a way of some sort, then you could also read the zoning bylaw to say that it could be considered as requiring a front yard setback. So that's why Neil and I went around on it, and you know, Greg's exactly right.
So,
We couldn't find case law, and we could find instances where, in our permitting process over the years, the line on, you know, that delineates that paper street from the main part of the property was considered, like in this case, a side lot line, and didn't require the major setback that a front lot line would require. Certainly, the rights to that paper street, even though for this property, as Greg said, maybe this property doesn't have rights to that for some reason or another, other abutters have rights to it, but the right is only to pass and repass, and nothing that's happening here would prevent the pass and repass, from happening.
I'm with you there, and I feel like I do recall past applications in my, I can't believe it now, considerable time on the board, where we have been comfortable with a side or almost side setback with paper streets. Here, it's not a paper street, but I think, and Greg, once again, correct me if I'm wrong, but existing conditions photo 2, I think makes it pretty clear, well, not a full-blown public way in Scituate, this is open and passable by vehicles at present.
So right now, as you pull in with a vehicle, I believe my client parks at that location right there.
Yep, I can see that.
But there are boulders across the street so that you cannot connect through to the constructed portion at the present time.
You can't connect all the way through, but you can drive down that paper street with a car to a point.
To a point, yes.
To a point
Yeah.
past this property line and into a butters on the left and right, or north and south, I should say, beyond this property?
That's
Not,
that section of road.
So, I'm sorry, Greg, I'm
Sorry.
sorry.
This here?
right
This whole thing?
That's Harbor Heights.
So where it's cut off?
Hazel Ave,
it's-
the house we're
it's-
looking
it's
at
cut
is this
off
one
right
right
about
there.
here.
Okay.
So,
So you can go from Hazel Ave to Harbor Heights up to the,
It's not-
this property.
it's not its own tax
Up
parcel.
to this property.
It's
Right,
not
but
its own
no
tax
further
parcel.
down.
no further.
So they have been coming through.
This is it here?
Because there is no, the garage is
This
not
is Harbor
left.
Heights Road.
They've been parking in the back of the lot, driving down.
nobody's
going
paying
back.
taxes on it.
Correct.
Right.
So it's not a private street?
So as of right now,
It's weirder.
whatever we
Okay.
do isn't really gonna change what's going on the rest of Harbor Heights Road. And arguably, if anything, because the garage and driveway are gonna be constructed on Hazel Ave, right, it's going to prevent, they're not gonna be driving down any of Harbor Heights Road, and arguably won't ever drive down Harbor Heights Road.
I'm with you there. This is somewhat interesting. We're on the assessor's maps here. And it appears that Harbor Heights Road isn't taxed. Is that correct? Is that consistent with what you saw?
I didn't look at the taxation of Harbor
Wait,
Heights Road. I just know we don't have any ownership or fee in it.
Yeah. Absolutely. I don't know for a fact that you don't have any ownership of the fee. We get into the derelict fee statute, things get a little interesting when you abut a private way on a plan. Typically, in my day job, often deal with whether a road is public or private. One of the first things we look at is assessor's maps. If the road that we see that matches up with our survey or plan isn't within a tax parcel and you see a strip of untaxed land on your assessor's map, it's not entirely private because no one's been paying taxes on it for some period of time. This street appears, and I would like to show it to you. Where can we go back to? Our lot, oh, did I screw this up?
No, you're all right.
This is us
So
here?
this, yeah, this is our lot right there.
So we could show this to you. Harbor Heights Road is set up on our assessor's map as if it was public.
Yes.
That does not mean that it is public. It just, in my view, that makes it a little less of a paper street. So we have a paper street where we've been somewhat flexible, I think properly, with our 30-foot setback. In this instance, we have a road or street that is at least somewhat open to vehicular traffic, and a road that is, no one is paying taxes on, which is another tick box towards the more than just a paper street category. At this point, I think, as I like to do, I've showed my hand. I'm not feeling entirely comfortable about approving an 8.5-foot setback from this road for new construction.
Okay.
I'm not saying I think it needs to be 30.
Mm-hmm.
At this point, I am not sure what it should be, but I don't think this falls into the category where I've seen us be comfortable with an 8-foot setback in the past. Bob, I welcome your thoughts. You've been at this for longer than me.
I think, I've said and you've heard that there's two ways to look at it, and we've looked at it both ways. And, I'm not sure one has trumped another. I would only say in somewhat defense of this solution that you're not being asked to create a new nonconformity. It's already nonconforming if you look at the road.
I think that's right.
In the sense of, being a public or quasi-public road. So it's increasing an existing nonconformity.
I think that's right, and I don't think that the applicant needs a variance nor needs to meet the variance standard.
Yep.
I do think, and I think we've dealt with this before, in significant increases in a front setback where we're coming this close, the surrounding neighborhood gets bigger when we're dealing with a way. And, well, 30 feet from a way is a lot. 8 feet is a lot less than 30, or 8.6 feet is a lot less than 30. Where there is a lot of building envelope left on this lot, obviously we'd love to have a wider house. What are the applicant's thoughts about going deeper rather than quite this wide?
Yeah. I think, at this time, what I'd like to do is to request a continuance to your next meeting. That's going to allow me time to investigate average front yards along Harbor Heights as
That would
well.
be very helpful.
Which I think would be helpful to all of us, and to discuss that possibility with my client who's not with us tonight.
Yes.
So if we could continue this to your next meeting, that would be appreciated.
Yes, and just before we have a motion on that, I absolutely think, and we probably should have mentioned it, that average setbacks from Harbor Heights aren't going to make us any more concerned.
Mm-hmm.
They could possibly make us less concerned, as I think you understand.
Yes.
So I would make a motion to grant the request for continuance to our May 19th. I think it's 19th, but May 19th hearing.
I do believe you did have a hand raised, just so you're aware.
Yes, thank you, Seth.
Well, that, I forget who it was, you did.
Didn't close the public,
We didn't.
no,
But we didn't
that is
say-
on my fault, that's my fault there. We were going ahead trying to get into the issue. So we had a hand,
If you want to start your video again, and you may not.
I don't see any hand raised.
Seth, do you call whose hand was raised?
He started his video and just waved his hand, but that was it, so.
Okay, we'll give him or her one more second to turn their video back on. If they would like to make a comment, we would like to hear it. I apologize for moving past that when we had a break there. All right. Yes, sir.
I don't believe he is.
Okay.
Neil Sorensen, 56 Hazel Ave. Just a question on Harbor Heights Road. The boulders that are blocking it off, did the town put those there? Can you answer that?
They just came recently.
They showed up within like the last 8 months.
I honestly have
There's
no,
never been anything there blocking the street. It's been wide open for the last 30 years.
They're very new.
yeah. And this would be on the other end of Harbor Heights Road from this property?
No, it's right, it's like literally almost behind Hazel Ave.
I got
And then
you.
they go
So,
down the.
so I would see
property
them
line.
in this existing conditions picture if
If you drove up.
you drove up a little further. Okay,
But you
I-
could always go straight through.
okay.
If these boulders
Yeah.
appeared, we don't know where they came from.
I don't
I mean,
know the answer to that.
who has the right to block off a public way or so-called.
Well, we don't have a title
Is it a
exam on this
public
property. It's, from looking at it, it's probably, and I'm guessing, not a public way fully, and maybe not a private way fully. The ownership and rights in that, in terms of passing and repassing, and who actually owns the dirt, gets very interesting, and we don't have enough time to get into that. But I don't know, I would be surprised if it was DPW or the town. But it could have been, we don't know that, and we didn't get comments from them in advance. Thank you.
Interesting.
So we have a motion to continue to May 19th. It's been, no, I think they gave up the shift, yeah.
Okay, so we'll close the public comment.
We'll close the public comment. We have the motion,
I'll second.
and all those in favor?
Aye.
Thank you very much.
Thank you.
Thank you.
We are continued to May 19th.
Thank you.
All right.
My guess, so we did drop this to last, right?
I think we're gonna drop it to
My
last.
guess is, that's
Okay.
McCarthy, yeah, McCarthy's on.
Yeah. I think we keep them last. and we
Yeah,
keep
yeah,
them
yeah.
moving.
That's fine.
Yeah.
That's fine.
All right, we're gonna go to our fourth application, and Mr. McCarthy, if you are now present in our Zoom section. Yep, I think you just got unmuted.
Hello? Hello?
Hi, Mr. McCarthy.
Yeah, I apologize tremendously for missing this earlier.
Yeah.
I don't, it just fell through the cracks somehow, I don't know, but.
It's not a problem at all. We moved you to the back of the line, which the line is a little bit shorter because we have some continuances. So we're gonna continue on with our fourth application. We will get to you.
Okay.
All right, thank you very much. Not a problem. We're going to move on to our fourth application brought by Stephen and Leslie Faber of 11 Cherry Lane in Scituate, and Richard and Karen Ross of 9 Cherry Lane, care of Jeffrey T. Angley, Esquire of Phillips and Angley at 1 Washington Mall, Boston, requesting an appeal pursuant to MGL 40A Section 8 and Section 15 of the building permit R220144 issued to Carol Howland on February 14th, 2022, concerning the property known as and located at 30 Ocean Avenue in Scituate. The permit authorizing work on the rear dwelling at 30 Ocean Avenue, known as 30A Ocean Avenue. Good evening.
Good evening.
30R, excuse me.
It says 30A in the notice.
Yeah, there was a.
Well, that's, all right, it is 30R, absolutely.
Okay, Matt Mitchell from Orenberger, DeLisi and Harris on behalf of Mr. and Mrs. Howland and Bobby.
Wonderful. Is the, sorry, we have the appellant's counsel
There,
here.
and the property owner's council.
Wonderful. How are you? Do we have you off mute yet, Attorney Shapiro?
Both are co-hosts, you should be able to unmute yourself. Alexander and Nicholas, you should be able to unmute yourself, yes?
Yes, now I'm able to, thank you.
Fantastic, thank you.
Wonderful.
Good evening.
Good evening.
Good evening. Thank you for permitting me to speak this evening. I'm doing my best Jeff Angley impersonation this evening, so who's out of the country. So
All right.
my name is Nicholas Shapiro, and I'm an attorney from Phillips and Angley in Boston. And our office represents the appellants Stephen and Leslie Faber and Richard and Karen Ross, the owners of the properties at 11 and 9 Cherry Lane, respectively. At issue tonight is my client's administrative appeal of the post hoc building permit issued to Carol Allen for the property at 38 Ocean Ave. The parties' properties are located in the mining area of Scituate near North Scituate Beach. Our client's properties directly abut the Howlands property along with the parties' shared backyard boundary line. The Howlands property is improved by 2 single-family dwellings, one denominated 30 Ocean Ave and the other 38 Ocean Ave. 38 Ocean Ave is set into the rear setback in close proximity to the parties' shared boundary line. Previously, as you all likely recall, in April of last year, this board granted the Howlands relief under General Laws, Chapter 48, Section 6, and the Scituate zoning bylaws, Section 6 Cognate, Section 810.2, for an addition to 38 Ocean Ave, in particular to provide greater space and amenities for the Howlands' developmentally disabled adult son and his live-in and health aid. Our clients appealed that decision to the land court, and that litigation remains pending. Earlier this year, meanwhile, the Howlands ostensibly sought to conduct some of the work at issue in the prior proceedings of the outstanding land court litigation that would be confined to the existing building envelope of 38 Ocean Ave. While we can understand why the Howlands would be eager to do this work, our clients in our office got no notice of the work, and no building permit was pulled for this work before it commenced. When it came to the building department's attention, the Howlands were required to obtain a post hoc building permit. This appeal was brought, and I'm here tonight because this recent work and the issuance of the post hoc building permit implicate legal claims and factual issues that are relevant to the disposition of land court litigation. In particular, the Howlands property is not simply the location of a pre-existing non-conforming structure, but also a non-conforming use, a second single-family dwelling on a single lot. Specifically, Section 430.1 of the bylaw prohibits 2 single-family dwellings on a single lot. In order for any building permit to issue to anyone for any development, the use reflected by the building permit must be authorized by local zoning. Here, there are 2 principal problems with the use. First, the Howlands assert pre-existing non-conforming status, but to this day have failed to prove that 38 Ocean Ave is a lawfully pre-existing non-conforming single-family dwelling. While our clients may be the appellants, it is actually the Howlands' burden to prove their pre-existing non-conforming status. In the land court litigation, through discovery, the Howlands have claimed that 38 Ocean Ave is a lawful pre-existing non-conforming quote-unquote carriage house. However, 38 Ocean Ave is not presently a carriage house. The plain meaning of a carriage house is a detached garage with an accessory dwelling unit.
So Attorney Shapiro, I want to, because it seems like you're making more than one point or some combining points. And we're, especially for some of the audience, we're getting into some legal aspects. So I'd like to handle them as you make them, if you can, and if that's okay, and obviously there'll be some crossover.
Yeah, absolutely. So broadly speaking, the 2 issues are, one, we don't believe that the Howlands have ever proved that this second single-family dwelling is in fact pre-existing non-conforming.
Sure, so let's address that point, if that's okay. And I understand we might go back to it in connection with your second or third points.
Sure, and so, yeah.
Go ahead.
So for that, we've been in litigation for a year, discovery's been done.
So I'm sorry, I do need to pause you there. I am familiar with the litigation in connection with our earlier special permit granting, but I'd like to, at least for a moment, keep that on a side burner because, and correct me if I'm misunderstanding, your first point is that the building permit issued for work within the existing 4 corners of a building on the property is work that is in furtherance or in order to accomplish the building out of a dwelling. And it's your contention, along with your contention that the property owner needs to prove otherwise, that maybe at least this wasn't a dwelling prior to the imposition of Situate's bylaw?
No, so to be completely precise.
Sure, let's do it.
It's that we do not believe that evidence has been adduced that demonstrates that 30A Ocean Ave as a single family dwelling, as a second single family dwelling at Locust, that there hasn't been facts adduced that conversion, presumably from a carriage. First of all, there's not evidence of the carriage house in the first place. As far as we could tell from assessor's records and the like, this property was first developed with the main house in 1910. We actually don't really even understand what the provenance of the carriage house claim is from the Howlands. But regardless, if it was a carriage house, at some point it became a single family dwelling, and there's been no facts adduced about when that happened.
Sure.
And more specifically, that it happened before Scituate adopted this fairly typical zoning provision that prohibits two principal, dwellings on a single lot.
Sure.
So our first issue is the Howlands ought to prove that before they get any building permits to do any work in the edifice.
Okay, so I'm not sure I agree, even though I imagine you might have some case law for me, that in order to get a building permit for interior work on an existing building, that a property owner needs to provide proof to the abutters that they qualify for that building permit. But let's put that aside for a moment and skip to what I think might be more important to your first point or count, let's say, is that I think that we do have some facts that maybe contradict some of your questions or contentions. I imagine your office pulled the building jacket for the property in their research for this hearing and the litigation. And in that process, did you happen across a 1966 building permit for work on the rear building?
We did not. Also, as it turns out, the production from the town is due tomorrow. So you're speaking of document production and litigation, which we're going to put aside for a minute. Sure.
But aside from any litigation and document production, the building jacket's available to anyone, whether or not they're party to a litigation, and you can come in and get it. And whether or not you've done that yet isn't really a big deal, because I can tell you now, and Janine, you're pretty familiar with this building jacket in particular, there is a building permit in the jacket from the mid-60s, 1966, relating to work on the rear building, the building on 30R. And that building permit refers to a dwelling or something of the like?
So it refers to refurbishing the existing rooms in chauffeur's quarters.
Quarters. That's close enough for me to dwelling. And that to me, and I will absolutely allow you to rebut, shows me that the building on 30R was living quarters at least prior to 1966. And I don't have in front of me, but our accessory dwelling, would that have been pre-existing if it was built in 1966?
I was told the accessory dwelling bylaw came into effect in '87, I believe.
And what about rear?
I don't know.
You don't know. But even if it's not pre-existing non-conforming, and I'd like to hear from you this as well, I'm sure you can give me the statutory citation. We have 10 years without a building permit and 6 years with the building permit, and this is certain, there's a building permit, and it's certainly been more than 6 years. So even if I wanted to, which I think you could probably tell I'm not inclined to yet at this point, how would we object to, within code, improvement of what was a dwelling more than 6 years ago and exists with a valid building permit?
to respond, that it sounds as if this 1966 building permit was for refurbishment to a carriage house. And a carriage house, both plain meaning, colloquially, a carriage house, again, is a detached garage with living quarters for the chauffeur. And so that is a different use than a single-family dwelling.
So
So,
I did see that in the materials that you submitted, and I see where you're going. I couldn't possibly disagree with it more. Someone was living there. What that person did from 9 to 5 or from 6 to 10 at night is of no consequence to me, and I'm not sure if I researched case law on use, which I did not. I'm pretty confident I wouldn't find any case law that showed a precedent for a change of use due to the occupation of who was sleeping in the bed. I honestly think, for lack of a better term, that's a bit of a stretch, arguing that that's a change of use. If someone was sleeping there in the 60s, it was a dwelling in the 60s, and it's a dwelling now.
Well, and we have and correct me if I'm wrong, I may be misunderstanding. There's a second building permit from 1988, which also applies to this building. And that building permit seeks to remodel the kitchen and the bath on the first floor, install a new bath on the second floor. Is that's what I'm asking, is that?
the 88 building permit, are we sure that's for the rear?
Yeah, the drawings are specifically the rear building.
So it's further built out in 88,
Right.
again, more than 6 years ago.
Well, and to that point, that's not a garage. There's a kitchen bath on the first floor.
And where I'm going is, even if it was, and
Right.
even if it was a carriage house for a chauffeur or a, whatever the term is for one who drives a carriage, the person that sleeps there today doesn't need to drive a carriage.
And again, it's not a garage, right? It's got a first of all, it's a full dwelling, according to this building permit.
In my opinion, and I am happy to hear from you why you disagree, we have proof that, we have some pretty decent proof that this is a pre-existing non-conforming dwelling. And even if we didn't, I think they have Massachusetts law on their side that it's allowed to be a dwelling now under our statute of limitations for permitting enforcement.
okay, well, so so a couple things. One, I would respectfully disagree with the notion that a carriage house is the same as a single-family dwelling. And if it would be helpful to the board, we could brief it, because different types of residential uses have very different types of definitions. I would point the board to the town's own definition of an ADU, which is a different type of residential unit than a single-family dwelling. So,
could you define ADU for the audience and for the record, please?
I do not recall directly off the top of my head the bylaw definition, but there is an ADU definition as part of the zoning.
I just meant layman's terms for us.
Yeah, so layman's terms, generally speaking, because ADUs are a hot topic throughout the country, generally speaking, ADUs have a limited amount of square footage.
I'm sorry, I would like you to explain to those of us in the audience and for the record who are not land use attorneys, what you mean by ADU.
What's the acronym mean to start?
The acronym is an accessory dwelling unit. So
Thank you.
So an accessory dwelling unit, colloquially sometimes referred to as an in-law unit.
Sure.
It has separate egress access. It's usually limited in terms of its square footage. Frequently, there's also limitations in terms of the number of bedrooms that are allowed to be in an ADU. Sometimes there's even limitations on whether you can have a kitchen in an ADU. So I just bring up ADUs as an example that zoning frequently treats different types of residential uses differently. And so I really honestly do believe that a carriage house is different than a dwelling unit. That said, and not having had the benefit of the building jacket yet, or the 88 permit, if that demonstrates that it's no longer a garage and was a dwelling unit, then that does call into question when the amendment took place to forbid multiple single-family dwellings on a single lot. If that amendment happened after 88, then I would concede, our office would concede that it is pre-existing non-conforming as to a second single-family dwelling on a unitary lot.
So,
Yeah.
hang on there, not after 88. Bob, you said the accessory dwelling portion of our bylaw was
87.
87. This was a dwelling in 66.
The second one was 88, it was a dwelling.
It was a dwelling in 66.
Well, so that chair, I respectfully disagree with you. I don't think a carriage house is a single-family dwelling. A carriage house is a discrete, idiosyncratic type of residential.
Not a single-family dwelling. It is not currently a single-family dwelling. The applicants are not seeking relief, and we're not seeking the building permit to make it a single-family dwelling. It is what I would refer to, for lack of an official explanation, a pre-existing non-conforming accessory dwelling. And honestly, I'm not sure it's a non-conforming accessory dwelling. It is non-conforming as to its setback. It's a pre-existing non-conforming structure as to setback, but again, one that exists with building permits and for more than 6 years, and obviously which exists for more than 10 years. But it is a dwelling. It is a dwelling occupied by members of the family. It is a dwelling that is, Bob, I think I'll ask this question from you. If they wanted to rent it today, put the building permit aside, the day before they started the work,
Right.
if they wanted to rent it, would they have been allowed to, notwithstanding the appellant's objection, in the opinion of the building department?
I've not seen the lower floor of this building. I've only seen plans of the upper floor,
Yep.
which I think is another point that I would at least want covered here.
Please.
The building permit that was issued was for changing an existing half bath, for lack of a better term, into a full bath, and for installing a non-structural petition to divide a large room into 2 smaller rooms, period.
A large room into 2 smaller rooms.
Right.
Was it to divide a large bedroom into 2 smaller bedrooms?
Yes, yes.
It was.
Yeah, that's what was written on the plans, right? And, we got fire department approval, and they stamped it for the location of smoke CO detectors, and we went through all of that.
Sure. And Attorney Shapiro, I want to let you come back to your legal argument, but first I have a question for you and your clients, and I want to know if the board shares this question. I feel as though I understand the reasoning behind your client's objection to our previously issued special permit. I think I mentioned in that hearing that was a complex decision, and we made our ruling, and I understood the objection of Mr. Faber at that time. I need to say, I don't understand your client's objection to this building permit. This is a structure that is there. This is a structure that, based on this building permit, isn't changing in any way that would be noticeable to your clients or have any effect on the enjoyment or use of their property. I guess now that they're making 1 bedroom, 2 bedrooms, possibly, so there could conceivably be an additional person habitating in that structure. I think we're all pretty aware as to why that is a desire. In looking at this, and before I got into the legal specifics of it, as I always try to do, and sometimes fail miserably, tried to put myself in the shoes of your client and said, well, wait a minute. This is, everybody wins. They're doing some stuff without changing the footprint at the moment. What is your client's objection to this building permit?
It's very simple in that we're in ongoing litigation, and the powers test issues, that is the second issue that I wanted to address, are implicated by this work. Obviously, doing work only within the building envelope presents a less, a less inherently, it's a harder argument under powers for the powers prongs to be implicated by only internal work.
So we're again, you're...
And he's implicated the land court case. I mean, that.
Yeah, and so I don't, even though I received advice that I should maybe think about stopping you from talking about the litigation, I don't want to do that entirely because I think that would be unfair to you. I understand that you're going to make a contention that this is related to that, so I'm not sure it would be proper to stop you from talking about it entirely. I would ask, so you just referred to a case.
Correct.
We have the landowners obviously here, we have other abutters, we have other people who are interested. I'd like to tone down the legalese a little bit in your presentation if we can. We could still get into it. We have some attorneys on the board. We'll stick with you, but I'd like to, so let's get into your second point unless you guys have something to stop him on the first point, please.
Well, it's all the same, right, issues. I wonder if you want to hear on this point from, I'm just asking particularly, how you want to, if we're going to do it one by one.
Attorney Shapiro, what do you think? Should we hear from the landowner and some other abutters on your first point?
I think they're so intrinsically linked that it probably would be a mistake not to handle them together.
Okay, so let's see if we can hear from you somewhat quickly and with a little less case citation, which I'm sure will come up in land court, on your second point.
Yes. Yeah, so my client's issues with what has been, with what happened before was a combination of, there's a pre-existing non-conforming structure that's being changed. But from our perspective, and I understand that the board may not share our view 100% on this matter, from our perspective, there also is a expansion of a pre-existing non-conforming use. And the case that I mentioned sets the standard for determining when you can expand a pre-existing non-conforming use lawfully and when you can't. And you can't when it's a substantial expansion or change in use, and you can when it's under that threshold. And so the reason why this administrative appeal is quite frankly legally necessary for my clients to preserve their rights in the litigation, and I don't want to get into it more than that. We needed to bring this appeal because from our perspective, this is all pre-existing non-conforming use. And any kind of work to expand that at least raises the specter of powers and this extension, whether it's a lawful extension or not. And quite frankly, from our perspective, up to this point, we don't feel like we've even really been able to have a conversation with any town officials about this aspect of what's going on next door. And so, I mean, frankly, this conversation is good because we're now starting to hash out these issues in a more open fashion than in the last proceedings.
Right, and arguably, I'm discussing a matter which I'm technically being sued on with the plaintiff's counsel without the benefit of my counsel, which, as you can imagine, makes this a little complicated.
Yes, I understand that.
But such is our lives.
Yes. So that's the second issue, is that whenever you're doing work to a thing that we believe is a pre-existing non-conforming use, some kind of calculus, some kind of inquiry, some kind of analysis needed to happen at the town level before this post hoc building permit issued. And just to circle back to a comment that you made earlier, Chair, every building permit does double duty as far as my understanding of land use law is. It does double duty because it's a building code certification but it also is a certification that the use that's going on in a structure is legal. And so for that reason, we brought this appeal, because as far as we can tell, the building department has not considered whether what is being proposed to be done and what has been done implicates, an unlawful expansion of a pre-existing non-conforming use without
Sure.
use variance. And
So I'd like to give the building department and the board a chance to respond on that
Sure.
point. So,
Of course.
Bob, just to restate his point quickly, I'd like to hear from you on the building department's consideration when you received this building permit for the work within, I think we're going from a half bath to a full, making one room two.
On the second floor.
You considering whether or not this was a change or unacceptable change or expansion in use?
Well, since the original plan that we were shown was a bedroom and a half bathroom, it didn't seem as though changing that to 2 smaller bedrooms and a full bathroom was that, much of a change. I'll come back to the fact that you can have an exercise room with a full bathroom over your garage. You can have an office with a full bathroom, or anything, a range of uses that have nothing to do with the basic use of the building, or putting it another way, are perfectly acceptable across several different uses for the entire building. There was no reason to think that the building itself had to be legalized before, remember what we're talking about, 25 linear feet of non-structural petition and 2 toilet fixtures. That's what this permit is for.
Right, and you weren't.
And that's all it's for.
And
And you could do that piece of building practically any place in practically any sort of residential structure,
and if this was,
and no eyebrows would be raised, at least in my office.
and if this was just a garage before, or even just a garage and an office before, and they were adding a new bathroom and a new room, you would have felt differently. Am I correct? Or no?
No, I think my point is that it would have been appropriate in a range of different cases for a range of different uses of the building, whether it were a garage, whether it were a workshop, whether it were a dwelling. The answer to that question did not impact the issuance of this permit.
So what, correct me if I'm wrong, and for the audience, our lack of familiarity with the accessory dwelling section of our bylaw in comparison to our familiarity with some other sections is because the planning board gets involved in accessory dwellings, and we don't get as involved in the new permitting of them.
Well, that may be, but
And
my familiarity is quite,
and that's why I'm going to,
I think.
what is the difference between me taking my garage and adding a bathroom and office above it, and me taking my garage and making it an accessory dwelling?
Well, if it wanted to be a legal accessory dwelling, it would have to meet setbacks.
Yep.
Or be pre-existing non-conforming and
Yes.
judged therefore not to need to meet setbacks.
Sure, but I mean in terms of the interior attributes, what's the difference there?
The trigger point in Scituate for an accessory dwelling is kind of interesting. You can go all the way towards a self-contained dwelling unit if you stop prior to installing a range, a stovetop with an oven. If you don't have one of those, then you don't have an accessory dwelling in the strictest legal sense. And that's the way we've administered it and judged it for a long time.
And we know that there's been a kitchen in this building since at least 1988.
Yes.
And possibly,
And a bath on the first floor.
and possibly if we dug further, there was probably some sort of cooking implemented in 66 since we were calling it a quarters.
Just to note on that, the building permit is actually a renovation for that kitchen, so it pre-existed 1988 and probably went back to
I have no reason
66.
to believe there wasn't a kitchen in
Right,
it in
okay.
66
It
when it
does-
was a quarters.
That's right, and it does say, to your point, it does say remodel the kitchen and the bath on the first floor, so they would have.
So Attorney Shapiro, that was in, go ahead, Bob, please.
We also have floor plans from that same permit.
And which permit are you?
The 88.
Uh, This one, I'm trying to see is this the 88 permit? Yes, floor plans are dated 87, actually, so it would be the 88 permit, which do show an accessory dwelling layout, full kitchen, 2 bedrooms in this case, interestingly enough, not a single bedroom. So the new plan reverts to the 2 bedrooms that were there in 87.
So,
Presumably 88.
yes,
Anthony,
just your name and your address or your connection if you're here in an official capacity for the record, please.
sure. My name is Jeff Delisi. I'm a lawyer with Ornberger, Delisi and Harris. I'm here tonight with my colleague, Matt Mitchell, who's also a lawyer. I just wanted to point out a few things just to address kind of topics that you've just covered.
Sure.
Number one, in 1988, an occupancy permit would have been issued. Under the zoning bylaw, under the occupancy permit portion of the zoning bylaw, it indicates that the issuance of an occupancy permit is an affirmation that all of the uses of the subject property comply with zoning. So in a sense, we've already have a determination on the issue of use, and there is a 6-year statute of limitations with respect to that.
Yes.
Also, on the issue of the floor plan, in 1988, the plans that you have indicate that there was a kitchen, there was a bathroom, there was a living room on the first floor, and then on the second floor, there was a master bathroom and 2 bedrooms, not 1, 2 bedrooms. That was what existed prior to the 1988 permit and what was proposed and ultimately what it ended up being and is today.
So I'm sorry, just to clarify, it was 3 bedrooms in 1988.
It was a living room.
Well, it was
2 bedrooms.
2 bedrooms and a living room in 1988. And the building permit is to take one of those 2 bedrooms and split it into 2 rooms?
No, actually, one of the bedrooms becomes an enlarged bathroom,
Yep.
and the other is split into 2 rooms.
So it's a net 2.
Yeah,
So
it's,
So, right.
2 bedrooms
Bedroom
now.
count.
They're not changing the amount of
Right,
bedrooms.
2 and
They're not
2.
changing the
You're not
amount
changing
of,
the amount of square feet.
2 and 2.
Plus a half bath,
Right.
Yeah.
basically net out, right?
And the reason that was done is because they need an industrial laundry situation for Bobby and a tub because of his skin condition.
And I don't, the reason I'm cutting you off for the motivations is because I'm not sure you need to prove to us your motivations.
Right.
I think if you needed to, you'd be in a very good spot in this instance. But Attorney Shapiro, to bring it back to you.
One more item.
I'm going to hold you off for 1 second. I'm sorry. We are going to come back to you. What I was about to say, Attorney Shapiro, is I think I have an overflowing cornucopia of evidence that this is a pre-existing, non-conforming dwelling, and they are arguably making almost no substantial change to it with this building permit. I think I have so much more evidence than we almost ever have in the issuance of validly granted building permits in the town of Scituate and elsewhere in the Commonwealth. I asked a question before as to why your client, I think you did an admirable job answering it, I'm not sure how much of your second point we're going to get into tonight, to be perfectly honest, and I'm gonna, these gentlemen can certainly disagree with me, but I think that's really discussion for the land court litigation, and I imagine, though it is up to you and your client to decide, that our decision tonight might become part of that litigation, but thus far, I have seen an abundance of evidence that we have a pre-existing non-conforming dwelling and that these changes to it couldn't possibly be considered substantially more detrimental to the surrounding neighborhood.
And, yeah, I mean, because the net of this is converting a half bath to a full bath.
Yeah.
That's the net. We're not adding any bedrooms, right? It's an industrial laundry and expanding a bathroom upstairs.
Yes.
That's what I'm hearing. That's what I'm hearing. You know, I can be corrected by other people, so.
Attorney DeLisi.
Just briefly, the single-family dwelling is defined in your bylaw as a building containing one dwelling unit and allowed accessory uses, okay? That's the first point. The second point is, in the worst-case scenario here, even if there is not a pre-existing non-conforming second dwelling on the property, clearly there's a pre-existing non-conforming accessory dwelling at the very least, okay? And then third issue really deals with the fact that we're talking about use in the context of the appeal of a building permit to basically add a half bath and some fixtures is really what it comes down to. This appeal, in my estimation, is nothing more than an attempt to bootstrap the use question on top of your prior approved permit for an extension of a pre-existing non-conforming building.
So
that didn't deal with use.
I know, I'm gonna stop you
We
there as
never
well.
asked for a change in use.
Attorney DeLisi, I'm definitely
It wasn't
going to
appropriate.
stop you there.
And I think we...
By stop, I actually meant the literal definition of stop. So, I stopped Attorney Shapiro from getting into matters that are for proceedings in land court. I'm going to do you the same service or disservice, however you want to look at it. We are here tonight to rule and hear on an appeal of the building permit for the changes we've discussed within the four corners of an existing structure. And I want to keep the discussion to that because I think the discussion is far more simple than the greater discussion, which I think reasonable minds can and will differ on how related or unrelated this is to that. And that will have an opportunity for discussion and will be presided over by someone far more qualified than I, and dare I say us.
Yes.
All right. Attorney Shapiro, given where we want to go with staying away from your reasoning for bringing this, in terms of the building permit, what else do we need to hear from you before we maybe hear again from the property owners council and then from abutters in the public?
I don't think anything more, Chair. I mean, if this is a pre-existing non-conforming use, then it is literally, this was a appeal that needed to be brought in order to avoid any kind of preclusive stuff if we didn't bring the appeal and then an appeal was made.
I understand, it's been brought, so here we are.
Okay.
Yeah.
Councils.
Just before Matt speaks, I do think that I think the board ought to consider seriously as a threshold issue, the issue of the 6-year statute of limitations, which actually is a jurisdictional issue. And that's pretty much all I have to add in addition to what I've said.
Great.
So that's exactly what I was going to say, under 48 Section 7. So, I mean, the building permit was issued in 88, 6 years have passed. They're done, I think. It's a jurisdictional issue.
And you can go into more detail, but I think I'd like the decision at the very least, to address that.
So that gets, we are deep into law and precedents on this, and it is, I see where we all are going, and I guess we need to discuss this because I don't want to decide what we're putting in a potential decision after we make a ruling. We need to do it here. So let me say this. In my opinion, if I was an attorney for the landowner, I would want us to make some statements about our interpretation of the law with respect to use, because it would be better for me in the pending litigation. I don't know where he would, the appellant would obviously prefer that we did it. Councils, I feel like I'm of the opinion that it's our job here tonight to say our building department properly issued a building permit in our view, or improperly issued a building permit. Correct. I'm hesitant to go beyond that, mainly for the reasons I stated before. The land court's going to get into that, and the land court's better at it than us. If we thought the building permit was improperly issued, I think we would have to contend more with the statute of limitations, which is a matter of law. We haven't ruled yet and we haven't voted yet, but I'm not sure we think the building permit was improperly issued. I don't think there's much argument with your point. There's a structure that exists in Massachusetts, and a use that exists in Massachusetts for 10 years, regardless of building permit statute, has certain statute of limitation protections, and it only needs to be 6 years if there was a building permit. Here, there was a building permit. It's been 6 years. Been more than 6 years. So you're not going to get any argument from us. I'm not sure that needs to be in our decision on this, and I don't want to set precedents for us to start citing specific aspects of Massachusetts law when we uphold a building permit.
The facts are the facts as we know them, and the land court is going to do with them what they're going to do with them. I think for the purposes of our building permit, or just review this appeal of the building permit, we had a building that had 2 bedrooms, 1.5 baths, back in 1988, and we have a building that's going to have what appear to be 2 bedrooms, 2 baths after this building permit is done, right? Regardless, separate and apart from any expansion to the footprint of the building. So I think that's where we are on it right now. Public comment.
Yep.
I would suggest.
Anything else we missed before we go to the public?
No, I think it's an existing building. We're not increasing anything except half a bathroom. I believe the permit was correct.
Septic or sewer, I assume.
Septic,
They're not increasing
no
bedrooms
So you're not increasing
or
bedrooms, right?
or
It's net
bathroom.
zero
It's not another half bathroom. It is
It's not another bathroom.
It's not another bathroom.
Right.
So half bathroom to a bathroom. Right?
And the design of septic is based on number of bedrooms, actually.
Yeah.
So that's not changed.
Yeah. Public comment. If we have,
Let's go there first.
great.
On the video, we're going to go to the video first, and then we'll take the folks in the room. Okay, so anybody that's on Zoom that has comment on this.
Patty Lambert?
Ms. Lambert, if you would like to.
Mr. Chair,
I would like to point out from the planning board that this is not an approved accessory dwelling, so before this ends up back in the planning board again, this is a separate house.
Thank you. I don't think that there is any risk at present of this ending up back before the planning board.
Okay, just, the legalese talking about an accessory dwelling, it's not an approved accessory dwelling.
No, no one is
Thank you.
contending that. Thank you.
Thank you.
Appreciate it. Going once,
We have anyone else
on Zoom.
on our Zoom call that wants to raise their real or virtual hand?
Going twice. Okay.
Any?
We'll cut off the Zoom. Just
I think if someone else from
Yeah,
the Zoom
yeah,
wants to
right.
add,
We'll move here.
yeah. Anyone here tonight have anything to add? Yes, sir, just your name and address for the record, please.
Thank you. I'm Robert Howland, and I live at 30/30R Ocean Avenue. And I know it's not lost upon the board that the reason that this was done, this existing footprint renovation, was because of my son with special needs. Bobby, who's here today, who has Down syndrome and some medical complications. Essentially what we did was put in a soaking tub and some bigger laundry machines to allow the work for carrying him to be done easier. I think what's frustrating when I hear things like carriage house and all the legal ease that's behind this is I don't want the town to lose sight of the fact that we're talking about a young man with special needs, trying to get him to stay within our community, to be part of his neighborhood, and be part of his town. The action by Stephen and Leslie Faber and the Rosses, it's hard to imagine why somebody would be challenging.
Mr. Howland, I apologize for interrupting. Please try to avoid commenting on the litigation here.
Yeah, no,
I understand you have strong feelings about that.
No.
I think you understand why I'd like to keep this separate from that.
Absolutely. I'm not looking to comment on the litigation.
Sure.
I think it's important for the town, the people listening, and for the record, that what our family is trying to do is simply have our son Bobby live in the community and be part of the community. This renovation has had no detrimental effect on the plaintiffs or our neighborhood. So to be here tonight is, for me, it's sad that such an action would be brought, and that's all I really have to say. It's not representative of our community and the welcoming nature of our community and the people that are in our neighborhood. It's an outlier, and I just want to say that. But thank you very much.
Thank you.
Thank you.
Anyone else? Yes, ma'am.
My name is Carol Howland. My familiar name is Carrie. And this is Robert Howland III, otherwise known as Bobby. And Bobby would like to say something using his assistive technology. It's an application called ProLocal to Go. So could he just say a short statement?
Absolutely.
Would that be okay? Okay, so Bobby, and I'm just helping him a little bit. Okay, you know what, I'm gonna turn the volume up so you can hear it. Okay, ready, so here we go.
My name is Bobby Howland. I am 22 years old. I live in Scituate. I need help caring for my medical needs. I need a large bathtub with jets. I need my own washer and dryer for medical reasons. I need storage for my medical supplies. My caregivers need a space that is large and safe to meet my medical needs. Sometimes I need medical care overnight. I need caregivers who can help me overnight. banked road keeps me safe and healthy. My new banked road makes it easier for me and my caregivers. Thank you for listening to me.
Thank you very much. Thank you.
Thank you.
Anything else from the public, or we'll even go back to Zoom if we need to? I know we're still figuring out the hybrid meeting process. I think we are all set with public comment. We'll close that now. Council, anything else to add or request or discuss before we possibly have a motion?
The only thing I would ask the chair is if we're gonna, I didn't get a chance to talk about the statute of limitations, but if that's not gonna be an issue, then you don't need to hear from me.
That's not an issue.
I don't think it's an issue for myself either. I'll make a motion that the building permit issued for the interior amendment and renovation to the property at 30R, which is noted as 30A in the hearing notice, to deny the appeal of that building permit, and for the board to find that the building permit was properly granted with respect to use and bylaw otherwise. All those in favor?
Aye.
Aye. There we go. Thank you. Attorney Shapiro, we've had some discussion in the past with other applicants when we issue a denial. We do not typically issue a written decision. The meeting minutes go up, they are available, they are part of the public record. Is that acceptable to you and your client? Obviously, this denial is something that you're going to more than talk about after this fact. We would like to accommodate you however needed.
Thank you, Chair. I mean, from our perspective, as long as there's some kind of writing filed with the town clerk's office at some point,
and
that's all.
And there will be, the meeting minutes will be filed with the town clerk's office, and so that will take care of it. If not, and you do need a writing, please be in touch with the building department. They will get in touch with me, and we will figure that out.
Great, thank you, Chair.
You're welcome.
Thank you.
Thank you.
Thank you.
Thank you all.
Thank you. Yep. First. We are going to move forward to our fifth application brought by Kenton Bogerzone of 17 Gate Circle in Scituate, requesting a variance in accordance with 950.2C of the bylaw, seeking a variance from the requirements of 520.4A, which mandates a 150-foot non-disturbance buffer zone to tributaries in the Water Resource Protection District for the construction of a single-family home at 5 Williamsburg Lane. The applicant has requested a continuance to our May,
I believe that's the main meeting.
19th hearing. I'd make a motion that we allow that request and continue this application to May 19th.
I second that.
All those in favor?
Aye.
5 Williamsburg Lane has been continued to May 19th. We're going to move on to our sixth application brought by Kellyanne Wilson, trustee of the Kellyanne Wilson Trust, 2004. Care of Jeffrey DeLisi of Ornberger and DeLisi, requesting a special permit finding in accordance with MGL 48, Section 6 and Sections 950.2D and 810.2 of the bylaw, and any other relief that the Board of Appeals may grant, to raise a pre-existing non-conforming single-family residential dwelling on a pre-existing non-conforming lot in the Residence R3 zoning district at 113 River Street in Scituate, and to reconstruct a single-family dwelling thereon which will not create non-conformities and will not be substantially more detrimental or injurious to the neighborhood than the existing non-conforming structure or use. One thing
Jeff DeLisi, Ornberger, DeLisi, and Harris. I think you dropped my partner's last name on that.
I got bad news. He's left the firm.
Sorry about the verbose notice. So I represent the applicant here. I'm with Paul Marabito of Ross Engineering. I'm just going to kind of cut to the chase. While technically the property is partially located in a FEMA velocity zone and is entirely located in a special flood hazard zone, that being that at elevation 14 above sea level, 14 feet above sea level, FEMA considers the property subject to flooding. Despite all of that, the town has an overlay zoning district, which is the floodplain and watershed protection overlay district, and the property is actually not in that zoning district for some reason. So, therefore, a special permit. Yeah, a special permit's not required, even though we would meet the threshold anyway for a special permit. So this house, I mentioned the elevation of the special flood hazard area being elevation 14. The house is actually existing at elevation 11.9 feet above sea level. The concept is to reconstruct the house elevated onto piles such that the house no longer is subject to flooding, which is, from a conservation standpoint and a FEMA standpoint, exactly what the town and the state like to see. The lot is typical of Humrock. It's laid out as a pre-existing non-conforming as to area, lot width and lot frontage. The application materials contain the record plan, which shows basically all the lots basically created on that plan, which pre-existed zoning, were all about the same size. So everything out there is pretty much the same. The existing dwelling was constructed in 1950 according to the tax assessor record that you have in front of you. It's a small 576 square foot single story cottage, not a chauffeur's quarter or a carriage house. And it is conforming in all respects, except that it is pre-existing non-conforming on the front yard setback. It's at 18.4 feet off the front yard, or off the street, and the zone is a 30-foot zone. So presently, it's 18.4 feet. We're proposing to make the non-conforming setback slightly better. Met to Mets, it's really visually going to be no different, but it will be slightly further from River Street. And so the increase in the square footage of the gross floor area is large, but it's primarily due to the fact that we have a very small reconstructed dwelling, and essentially we're going up to 2.5 stories, which is going to be compliant with the height requirements of the bylaw. So the property, not only is the property similar to other properties, but the proposed home is similar to many other properties that have been recently reconstructed, say in the last 20 years or so, out there in Humrock, with all of the encouragement of the FEMA funds and everything else. So the standard under Section 810.2 is not substantially more detrimental to the neighborhood than what's there now, and that's the same standard that's set forth in Mass General Law, Chapter 48, Section 6. So that's pretty much it. If you want to hear from Paul, or Paul's here to answer any questions from an engineering perspective about his plan, however you want to do it.
Marabito, I think this is relatively straightforward. You have?
I got nothing.
It's all here. Yeah. They're not.
That's what we try and accomplish.
No, I think we're making. We'll hear from the public and Bob, but we're making positive changes all around.
Yeah.
I mean, that's.
You first in the area, or the surrounding houses already up, or?
Yeah, in fact, I was here, I don't know, maybe a year and a half, 2 years ago.
For the White House?
For the White House is 2 houses down, it's up. Same exact scenario, small little cottage, boom, 2.5 story situation. Yeah.
They've got to improve their view to get around all the other bigger houses.
Yeah.
Bob, anything to ask?
No, it's an ideal project, you know, if we can get more houses elevated, we're gonna have less exposure to storm damage and storm events. It will require Conservation Commission approval, and they'll look at stormwater. I don't know offhand if you're increasing the impervious enough to trigger that, but that's another decision by another board. As far as this board's concerned, I think you're definitely good.
Anyone from the public on the 5 Williamsburg Lane application?
Yes, Scott Simmons, 47 Ocean Drive.
Thank you.
Curious about the septic design, and I see from the proposed drawing that the existing roof structure that is non-compliant to the setbacks is to remain. I believe that people do what they want to plan, but I have a problem with planning of this as remove permanent property markers on my property that I paid a lot to have placed. So I'm curious why that building should be allowed to stay when non-compliant. Then I'm curious about the proposed septic. Is that going to be required to be above ground? And last, will you be staking my property line that will heavy equipment back into the backyard with the test? Thank you.
You're welcome, and we might come back to you. I want to make sure we get to all of your questions. First, on the stakes, Paul, unless you have anything to add,
What's the first question? The question on the...
I believe you saying that property stakes, property line markers for his property were removed. That seems to me like a private neighbor question and issue, and something that we try to avoid here when we can, unless you
I don't know.
have something to respond on.
I don't know of any property line markers that were removed. We certainly wouldn't do it as land surveyors. As far as the septic system, we have performed soil evaluations and perk tests in the presence of the Board of Health. There'll be a new septic system going in approximately at the rear portion of the house. Some of the leaching area will most likely be underneath the house in the area of the piles. There'll be a new septic tank and some leaching trenches. I mean, the groundwater was very low. We don't anticipate a mound out there. And the system should be very straightforward. As far as that small structure to the rear of the existing house, that's going to remain where it is. There's no plans for that.
Is that a shed or something, or what is that?
Pardon?
Is that just a shed?
What is it?
What is it? The small existing structure?
It's just an outbuilding that they have. It's an accessory building. They don't have, there's no bedroom in it.
So, and I'm sorry, Mr. Simmons, they are, removal of that building is not proposed, and obviously they could remove it without relief from this board, but they are not seeking to amend that building in the rear in any way, which is why it's not before us.
An existing roof. That's not true.
Whether or not that building is allowed to remain is really a separate question. I would imagine that it is likely a pre-existing non-conforming structure, which is why it wouldn't be raised as part of this application. I believe you had another question.
So the septic will be, it sounds like it will be below ground. They don't anticipate adding any dirt for a mound. That is what I heard. That the building in the back is probably non-conforming, but it's pre-existing, so it's grandfathered in. And then what was the first question second question.
Property stakes.
The property stakes, and nobody, nobody here knows anything about their removal or their moving of the property stakes. So we have no information to that effect.
You know,
Unless Jeff.
just to extend, no, I don't have any information on that, but this is land court, this is registered land. So, there is no ability to have, adverse possession against registered land properties. So
it is what it is.
It is what it is. Like, in other words, if the concern is you remove the stake because we have a property dispute, it can never change by virtue of the fact it's registered.
Mr. Simmons, was there a question in the end there about construction vehicles? Are you, I think you're muted now. Are you able, you may still be able to unmute yourself. There you go.
There you go.
Yeah, the host wasn't allowing me to unmute. No, my request was, as I said, happy to support people who like the property. Inadvertently, the stakes were run over, cast iron stakes. My request is respectfully to have them put back in.
Paul, you can do that. I don't want to have the client put them in because.
Second, I want to understand the precedence of the septic system. Bylaws changed. The house we built required above ground septic, so I don't see a proposed septic system.
Sure.
I'm curious about that.
Sure. So rest assured that the septic system will be built in compliance with the current regulations of the town and I imagine state. When that goes in, we are not the body to comment on that with any specificity. They are not seeking any relief from us regarding those septic regulations. And in terms of the stakes, we'd encourage you to talk to your neighbor. It seems like they might have the resources to figure that out with you, given what else they have going on at this property.
We're happy to put them back if they were our stakes, especially.
Yeah.
But if they're someone else's stakes, it might not be a good idea for Paul to put someone else's stakes back.
Yeah.
You're gonna have to stake. Look, you're gonna have to stake out the house anyway.
Yeah.
But accidentally ran over the property mark, so we'll deal with that off as requested outside of this forum. But now that now it's on public record. Again.
Okay, thank you, Mr. Simmons.
People wanting to do what they want to do with their home.
Great.
Thank you. Any other comments?
Anyone else? All right. Do we have, I'm making a mess over here. Do we, on the agenda. I will make a motion that the board find that the proposed raise and reconstruct shown on a plan drawn by Ross Engineering and dated March 15th, 2022 does not create any new nonconformities, and to the extent it intensifies any existing nonconformities, such intensification is not substantially more detrimental to the surrounding neighborhood. All those in favor?
Aye.
Aye. Aye.
Thank you very much.
Thank you.
Appreciate it.
Thank you. Would you,
Yep.
do us a service of a decision on that one?
Happy to.
I appreciate it. Thank you.
That's yours.
Have a good night, everyone.
You too?
You too.
Is he there?
Yes.
Wonderful. I appreciate your patience. It was not meant to be penal dropping you to the back of the line.
Rest of it.
We're just going to read your application into the record. This is our first application, which we moved to the end of property Thomas P. McCarthy of 49 Aberdeen Drive in Scituate, requesting a special permit finding in accordance with MGL 48 Section 6 and Section 810.2 of the bylaw and any other relief that the Board of Appeals may grant to allow the raising and reconstruction of a pre-existing non-conforming single-family dwelling at 121 Jericho Road in Scituate. increasing the gross floor area by more than 20%.
Thank you. Yeah, my name's Tom McCarthy. I'm a builder in Scituate. And this, what we propose to do is remove the existing dwelling, raise the existing dwelling, which now is on the, considerably out into the existing Jericho Road, and doesn't meet setbacks on the left side or the back side. And we would like to remove that and construct this new single-family, 4-bedroom dwelling, doing our best to meet all setbacks except some in the front, I believe. And our first floor elevation should be at 16.5, where elevation, the flood elevation there being 16, or 15 plus the extra foot. And that's about it for me for now. I'm not a lawyer, so I don't have a whole lot to say, but go ahead.
Congratulations on not being a lawyer, by the way.
Thank you.
It's not all it's cracked up to be. So if you could answer a couple questions about your plan, just because as you can imagine, the detail is great. It's a little tough to read at 8.5 by 11. Our existing setbacks, just because we've got a lot going on here, I was having a hard time when I reviewed this.
Yes.
The existing dwelling is to the south of the lot, away from Foam Road on Jericho.
That's correct.
And our non-conformity, well, first of all, on the lot, because I don't think we had the benefit of the chart on this.
I see it.
Do we have lot non-conformities here? And Bob, please feel free to jump in if you have that information.
Do we have any with the existing home or the new
With
home?
the layout of the lot.
Well, it's the lot size maybe, which is what makes it pre-existing non-conforming, I believe.
So the frontage is 125.
Which is great.
And the width is 134. Which is
great.
The area is,
stop me if I'm off, please.
the area according to this is 8,000, 1,100.
Which is going to be non-conforming.
Right.
What district are we in? That was left blank as well.
It's R3.
Thank you.
Yep.
So we have lot area, and otherwise we are conforming on the lot. That sounds right? And Mr. McCarthy, we are trying to go through this now in order to avoid having you come back with a plan that speaks more specifically to these things, so we appreciate you bearing with us.
Oh, absolutely, yep.
I thought you might be on board with that.
So what are the current, on the existing dwelling, what are the current setbacks?
I think I've deciphered that.
Okay, Bob.
Please go ahead, Bob.
Do the best.
Front yard, it's in the layout of the road. Both front corners are
Yes.
over the property line in the layout of the road. Rear yard setback appears to be 9.3 feet of the this is the existing dwelling.
Which would be compliant.
No, rear yard needs to
20.
be 20 feet
Yep,
to be compliant.
yep.
Side yard appears to be fine. So those are the nonconformities of the structure itself within the lot.
So the front, I'm sorry, the front is?
The front is
Well, the
negative.
front is, yeah,
Oh, it's over.
mine is several feet, right.
So now, Mr. McCarthy, the new home, the proposed home would be, it was a little easier to read. It looks like we're gonna get further away from the lot line, still be non-conforming at 10 feet at its closest point?
Yes, that's correct, yes. That's the way I read it.
Proposed 10 feet?
Where did you
Correction.
find, he has 5.1, 5 foot
It's
1
five,
inch.
it's either 5'1" or 5'4", about 2/3 of the way.
The front.
Yeah, the front corner closest to Jericho is 5-point-something feet.
So,
Looks like 5.
Oh, I get the wrong one, I'm sorry.
I'm sorry. I I was hoping that maybe we'd have a better plan than when we got here, or some more information. I'm not sure I can rule on a special permit with this plan and without a chart. This board in the past has been incredibly stringent, in prior iterations of this board, on having a plan where we were clearly able to read existing and proposed setbacks, and we've then been a little bit more lax with maybe if we have the chart that clearly lays it out. We don't have that here. It seems like we're not 100% clear on it in the hearing. This likely isn't a very complex application and is probably headed towards an approval. We have an incredibly non-conforming building in terms of setbacks.
Right.
It appears as though we are likely making it a bit less non-conforming, and that is something that board has traditionally approved. But Mr. McCarthy, what I think we are going to need from you is a plan that I think we need a full-size plan.
Yes. Yes.
And that plan should include an environmental, and Millbrook Survey will have done this before. I've seen their full-size plans come before this board. We need to see our chart. Lot characteristics, setbacks characteristics, both existing and proposed. And I wanted to try to give it the college try to not make you come back with a larger plan, but we have too many setbacks. Setback nonconformities are significant on this lot, and there's a lot changing, and there's a lot of points of contact. We really do need a full-size plan on this application.
Okay.
Yep, and that full-size plan should include the chart. Bob, please.
I would also suggest you might bolster the case for this layout by taking the average setbacks of homes along Jericho, which are, I'm sure, closer than the 30 feet mandated by the zoning bylaw. So the average is going to help you. You won't probably achieve that average setback, but you'll be a lot closer to the average than you would be to the 30 foot.
Yeah.
Yeah, exactly. I believe he's already done that too. It's my engineer, he just could not be here tonight, so. You're right, yeah. Okay.
So that would be very helpful. To the extent they need space, we don't need the flood vent detail and things like that on this plan. It's okay if it stays. We do need a clear chart and be able to see on the plan all the setbacks and lot characteristics and measurements.
Very good.
So just before we let you go, I would like to hear from the public. Looks like we have a Mr. Holder or Holdy who's interested in speaking and has his or her hand raised. Yes, thank you.
I've been called him a few times, but come on, let me tonight. Just kidding. All right, I do have some concerns. I am currently located on Foam Road.
And your name for the record, please?
Yeah, it's Lynn Holder, and I'm currently at Foam Road. Okay, on our property, we have been in Scituate since the 1930s. I think most of Scituate is derived from, as I look at it, an Indian word called early settlers. You have early settlers on Farm Road. You have 3 to 4 generations of families like many in Scituate. My concern in regarding this family, the McCarthy's family that's been there for a lot of years, is what I've heard tonight from the planning board, and God love you, for all of you that, donate your time. I think it is important. What are the interests of the neighborhood? It does need to be a win-win. It doesn't mean because he met the setbacks, he did this, and that. There's a lot of things that are going to affect us in this neighborhood. As you guys know, because of the rise in the tide, Museum Beach is now the #1 beach that a lot of people go to. Privacy is going to become a little different for some of the neighborhood. sunlight, visual, flooding, stormwater. What is the value that's being added to the current people that live there?
So sorry, I'm sorry, ma'am, and I want to let you continue, but I do want to respond on a couple of those things. just
Okay,
because-
and I appreciate it, so I do appreciate it, so thank you.
Sure. First, this lot and current home is non-conforming. The standard that they will need to meet in their proposed reconstruction is that those non-conformities, to the extent they are changed or intensified, are not substantially more detrimental to the surrounding neighborhood. That is with respect to those non-conformities, and I will absolutely let you ask more questions or make more comments in a moment. That is with respect to those non-conformities to the bylaw. That is not with respect to benefiting the neighborhood otherwise. That is not with respect to protecting or not modifying the views of the neighborhood. And it's important that we make that distinction. Views of the water, sunlight views are always a concern of neighbors. I understand that. They are of a special concern in Scituate, especially in this neighborhood. They are not something that is protected by the bylaw.
And I understand that. And I don't think that, that's the main issue, you know,
Sure.
Of that. And I do appreciate you saying, you know, you said it's in a non-conforming lot. Is the previous speaker that had on there did address that the fact that he was in a non-conforming lot. He says the houses around him were built, you know, he was going based upon the height of the houses, that he's not doing anything different. I get that, but, you know, and, you know, I am just, you know, probably something that you hear all the time, but does a neighborhood, besides it's in a non-conforming lot, do we have a voice to say, hey, we do care the fact how that lot's gonna be used? I mean, I think all of you said that, you know, looking on his map, need to drive by this location. I think it is that important, and I always used to say, if I wanted a job, I would say coming down Fulham Road is the happiest place to give a tour bus. And, you know, I am concerned about that, because I think that house is gonna affect a lot of people, not view. You're gonna have a little more shade to the people around there. It's gonna block things. I don't know, maybe that's the way Scituate is now. It never, you know, is the fact the higher it goes, the better it is, as long as it's not conforming. I don't know.
So
I'm just, yeah, and I'm not trying to be, you know, I'm a little old school, so apologize for the way it is now.
You don't need to apologize at all. These are very valid questions, and they are not uncommon questions or concerns. They're questions or concerns that I would have if I lived in the neighborhood, and I understand because I frequent the neighborhood, living in Scituate. First, on the height, it's important to note, Scituate has a bylaw regarding height. There are some intricacies to it. The home's allowed to be 35 feet tall, without getting into the intricacies of it.
Okay, that's fair.
The home is not currently beyond that, so the home currently conforms as to height, and anything that they build on that lot will need to conform as to height. They can make the existing structure, the new structure can be taller, but it needs to comply with the bylaw.
Okay, so my question is, they cannot come back to the board and say, oh, we want an addition, I don't know the correct terminology, so excuse me.
You're fine.
Alterations, you know, we constantly come back, and my question is, are we gonna make sure that it is checked by the town? Because it is important, because as you see time after time, you know, where, hey, this is what the proposed plan was, and I'm not saying within the city of Scituate, don't get me wrong, or town, but yeah, it is important. And, you know, I want, you know, I do, and maybe I'm going off a little bit, but, you know, I want to make sure that, you know, that we're part of what's being built there. I think
so I do want to respond on that.
Thank you.
You're not going to be part of what's built there. really at all.
Okay.
I
Okay.
apologize, and I recognize that many citizens and members of different neighborhoods
Yeah.
don't like hearing that. And if I lived next door, I would want to be part of what was built there too. But it's their property and not the abutter's property and not my property. We have a zoning code that they need to comply with. They don't comply with certain aspects of it, and we're going to hear it once they bring back an acceptable plan that makes everything clear. It's very unlikely, because we've never done it before, as far as I know, we're not going to let what they build be less compliant than what is there now. That doesn't mean that what they build won't be less desirable to their neighbors. It may, and I expect it likely will. But the only way that I'm aware of to stop that, and I've been doing this for a little while, is to buy the property.
Sometimes before,
Okay, yeah, let me just say one thing, and well, I've said too many, probably.
You're all right.
Is, the thing is, from what I hear from you, and nothing personal, as we all know.
Please.
And I truly mean this, I'm not in your position, and I wouldn't want to be, so through there. But what I hear from you say, as long as you buy the property, as a community, you being part of that community, that as people that are concerned about the schools, concerned about whatever is done, that we, in this avenue that I'm speaking to, that I do not have a right or I have a concern, but I don't have the ability to make any changes, because as long as they meet your codes, the city's codes, that my word is really mute, even though we have a public forum.
Your word is not mute. You are given the avenue to express any concerns under our code and our bylaws, and and the laws as we are able to help you enforce them.
Yeah.
You don't have a teeth to your opinion beyond the code. There are private legal actions that you can take, that you should consult your own representation or research on. But for us, we are able to enforce the code. We can't make them more compliant than they are now. They have certain grandfathering is the term that we use, pre-existing non-conforming. They can't become more non-compliant. But in terms of enforcing things that you feel or your neighbors feel, or maybe even everyone agrees on would be better for the neighborhood, to the extent that falls outside of our zoning code, we cannot enforce those things.
Okay. And I do appreciate, I do appreciate your time and everyone that's there.
Absolutely, thank you.
So, in what I would say to the community of the town of Scituate, maybe you should, as a community, the reason that people are coming there is for its uniqueness and for the families that are there, is maybe looking at making changes somewhere down the road, because at some point, it will lose that charm. It doesn't mean on the thing of foam. And my other last comment, and thank all of you, and I appreciate you giving me the time, is we were mailed this arrangement to be here April 1st. It was mailed out, 20-day notice. And I understand Mr. McCarthy, we were first on the agenda. The rest of us have been waiting for 2 hours because he was late. And I know when I have to attend a meeting, if I'm coming in late, I'm not looking good. So my recommendation would be for the board, to people that are going to be showing up late, why are the rest of us having to wait? That's only a suggestion, but I do appreciate all of you, and I thank you for your time.
I understand your point there. It's well taken. It's something we'll consider. Somebody gets messed up no matter what when somebody doesn't show up. This is not, if Mr. McCarthy's late for the next hearing, we'll not be so gracious in how we handle it.
Can I say one thing? Can I rebut it all?
Yes, Mr. McCarthy, I try to keep things directed at the board, but yes, absolutely.
This will be very quick, very quick. I just want, I don't know if this woman knows me, I don't know, but I also grew up in Scituate, was born in Scituate, lived there most of my life. I've been a builder in Scituate for 40 years, and the people who sold that house to me, Roseanne and Jim McCarthy, are my cousins. And my cousins were also at 121 before that was sold, 123, I mean 117, 119, all my cousins. So yes, I'm very, I feel like I'm in the community or that area too. And the reason that house is being built like that is because Rose and Jim, first of all, Rose asked me many times to please build a righteous house there when she was done. And also, the amount of money that it was sold for meant that all her kids are now doing just wonderful. So I just wanted to say that don't think that I just blow into town and throw up this thing and check out. That's not the case.
Thank you.
All right?
Thank you. Thank you. Do we have any other public comment? Yes, I'm not going to do you the disservice of butchering your last name from this distance. Thank you, Seth. There we go.
Hey, Michael Luskis, 10 Foam Road. I oppose this project. The flooding in that lot is incredible. You put a bigger house, I oppose the size of the house, the location of the house. The water that's going to be displaced in that building is going to go right down the street to the rest of the neighbors. I don't know why the building has to be so big. I really oppose where it's located, especially the garage.
The garage.
It's just going to go flowing down the street. All seen the pictures of that house during the storms, even just a little nor'easter. That thing floods like crazy, and that's all I got to say. I just really do oppose it.
Sure, and we'll get into more specifics of location and measurements once they come back with a plan that lets us speak specifically.
How's the garage going to function on a flood plan?
The question is, we understand that Mr. McCarthy will get ever what he wants, but what we're worried about is the garage, and basically it'll be close to the street, so when you're pulling out, it's not safe. It won't be safe at all. When you look at those measurements, and we had to zoom in to look at those measurements, what he provided, it's not safe. And the monstrosity that he is designing, it's too big for that.
Crossing Jericho Road right now from Foam Road to get to Museum Beach is really difficult. And I think when you put the garage there, he likes to put fences around his buildings.
Yeah, he puts about a 7-foot fence around every building. So you look at the one that he put on Otis, and that is, that's another family property that he did such a great job with.
Folks, we're gonna.
Ma'am, now you didn't put the fence
No,
up.
Mr. McCarthy, we're gonna hang on.
I got you.
We're gonna hang on for a moment.
That's kind of, if they put a, if they
Folks, we're gonna shut it down. We'll shut it down. All right? Thank you, Mr. Arlaskis, Mrs. Arlaskis. Thanks for your comments. Mr. McCarthy, I don't think we need a rebuttal on those. Obviously, we got into some personal feelings about building size. To go to some of your earlier comments, you have some questions about location, measurements, setbacks, which are absolutely, they are germane and apropos to what we're going to talk about here. That's going to be moved to when the applicant is able to come back with a plan that we can all read without squinting or worse, and we're going to be able to discuss specifics. He's not going to be able to build whatever he wants automatically, sort of resented that comment. We're going to enforce the code to the extent we can. Do we have anyone else from the public that is able or would like to make a comment? No. All right. We're going to close the public comments for this application. And Mr. McCarthy, we need you to request a continuance if you would like to, or you can request that we rule on your application now, which I would not recommend if you want us to potentially approve your application. Because you'd need 2 of the 3 of us, and you'd be getting a no from me if you make us rule now. So but it's up to you, but would you like to request a continuance to our next hearing? Can't unmute him, and actually, hang on, Janine, we've got quite the roster next month, don't we?
Including tonight, it will be 10.
So, Mr. McCarthy, would you like to request a continuance to as soon as we are willing to hear you again?
I cannot unmute Mr. McCarthy.
We're trying to unmute you, please hold on one second, and George, if you have something to say, please.
No, I was gonna say, Seth, can you do some of your magic?
Mr. McCarthy has been asked to unmute. He has not unmuted himself. Mr. McCarthy?
So there's a mute button, Mr. McCarthy, if you can hear us.
Mr. McCarthy, bottom left-hand corner of your screen, right down there. There you go.
There
we go.
Is that it?
That's
Am I on now?
it.
Sounds like you got IT to help, we like that.
I think you got that right.
Yep.
Absolutely. And yes, I would, yes, as soon as you could, and I would, yes, continue, yeah.
Okay, and I would make a motion that we continue our application for the property at 121 Jericho Road to our June hearing, given that we are well into double digits for our May hearing applications at this point, and to our June hearing, which will be
16th.
on the 16th of June. Do I have a second?
Okay.
Second.
All those in favor?
Aye.
Aye. All right, you are continued to June 16th.
Thank you, sir.
Thank you. Thank you very much.
Thank you.
Minutes?
Janine, we have some minutes?
No, I didn't.
We don't have some minutes. All right.
Close it up.
Have a motion to adjourn?
I move that we adjourn.
I second.
All in favor?
Aye.
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 We are adjourned. Thank you very much, everyone.
Recording